Ernst Hirsch is a Turkish-German law professor with Jewish origins. The reason why we specifically said that he has Jewish origins is because it is the reason of his arrival of Turkey. He was dismissed from his university in Germany in 1933 due to his Jewish origin. After he came to Turkey, he had significant activities about every field of Turkish law. He learned Turkish fast, and his contributions to Turkish law is irreplaceable. I want to talk about his very important book that can be translated to English like this: Methods for the Practice of Law. This book contains serious suggestions for all law people in a country. This book is one of the primary resources recommended for future legists. According to Hirsch, what a legist does is solving the legal problem, just like it is a mathematical problem. The aim of Hirsch's book is to shed a light on the problem-solving stage for legists. Although law is a field that's constantly changing through time, also it is different for each country in the world. Method for the practice of law is not in such a motion. The book named Methods for the Practice of Law consists of 2 parts in total. In the first chapter, how to solve a legal problem is explained in 17 subtitles. In the second part, there is given some real-life examples, and Hirsch made some evaluations. I wish for this book to be translated to English, since it is a valuable source for not only Turkish law, but for the whole practice of law in the world. This video consists of my own thoughts and assessments of this book. Let's examine what kind of formula Hirsch has used to solve a legal problem. First subtitle is the case. 2 aspects are important in resolving a dispute. First is to discover the legal problems that constitute the basis of the dispute or problem, and second is to give a rational and convincing answer to the question of the dispute. When a dispute occurs, it is necessary to examine the dispute from the perspective of a legist in order to find the main problem, because a dispute has different meanings for people with different expertise, and sometimes there is even no legal problem according to them. But a legist's point of view will be very different. It is very difficult to examine a case with a lawyer's eye, because the word law contains thousands of legal rules. Every legal norm consists of 2 parts. In the first part of the legal norm, the rules and conditions of the norm are specified. In the second part, the result is written. In this case, if the conditions stipulated in the first part of the rule are fulfilled, the result specified in the second part of the rule will actualize. In a concrete case, the actualization of the conditions stipulated in the first part of the law will ensure that the rule of law is applied to that event. In this case, it is important to determine the problem that the event is based on correctly. In other words, when describing an event, the lawyer should ask the right questions in order to identify the event with its legally important parties. The most important step to be understood from the subtitle of case is to determine the case containing the legal dispute correctly, and the lawyer should identify the right legal problems by appropriating the case. Okay, the second subtitle is question. After the case is understood correctly, it is necessary to determine which legal issue is concerned with the explanations to be made in order to solve the legal problem. This means that the question to be asked must be determined correctly. Here stated that identifying the legal problems in a case is a separate stage itself. Third subtitle is law order. The duty of a lawyer is, of course, to examine the case in terms of law. When we say law, we are talking about the existence of a legal order. Since the concept of law is a rather vague, ever-changing and diverse expression, it can sometimes be difficult to determine what we should understand from this concept. The 2 most important contacts that we will encounter while determining the law are time and place factors. The rule of law to be applied will be determined according to the place where the event took place and the time it took place. Although this may seem easy, the difficulty can often start from the stage of determining the rule of law. The right rules of law will be found according to the norms that determine the effective time of the law and the rules of international private law. In other words, in the third stage, the law to be applied to the event should be determined in terms of place and time. Fourth subtitle is qualification. When the correctly determined legal rule is evaluated correctly and a match between the concrete case and the rule is achieved, the result envisaged in the legal rule can now be applied. After finding the legal order to be applied for qualification, which is the 4th rule of Hirsch, what needs to be done is to determine whether the case has an equivalent in the mentioned legal order. Here, too, the difficulty lies in finding the exact article of law to be applied. It is not possible to to examine the laws in force one by one in order to find the article to be applied. There are countless laws in each legal order. Of course, while determining the law, there are methods applied by the lawyer, by legal. Moreover, the laws are arranged in a certain systematic. They're not in a random order. In fact, what a lawyer should know best is not to know everything, but to know where to find something. This systematic in legal systems have been made from general to specific, or according to the connections to the main heading. According to Hirsch, the distinction between public law and private law, which still today finds its place in theory and partly in practice from Roman law to the present, does not work very well. The distinction and classifications made are generally artificial that remain in theory. What is meant by these artificial distinctions are sections such as criminal law, administrative law, law of obligations. The lawyer will find the rules of law by using these distinctions. This means that the duty of the lawyer is to determine in which class of law a case takes place. It should also be noted that this determination will be different for each legal order, even though the difference between legal systems, which we sometimes encounter even in the basic concepts, makes the job of the lawyer very difficult. An experienced lawyer who understands the regulation of laws and title order can easily find what he's looking for thanks to this system. The most important point here is that the case is translated into the legal language correctly, and the system in the legal order to be applied to the event is known correctly. In other words, at this stage, the dispute should be analyzed correctly and evaluated comparatively with the legal order. Fifth subtitle is the type of the case. The explanations made in this part is mostly based in Turkish law. Two principles that dominate the modern procedure law describe the cooperation between the judge and the parties like this. The first rule is the law is known by the court. The second is explain the case and I will give the verdict. The judge is not bound by the qualifications that parties make in the case. Although the judge is bound by the case and the request claimed by the parties, it is not bound by the qualifications and the provision of the law. The judge does not have to take into account the qualification or the law on which the petition is based. In this case, the important thing is the concrete case and demand rather than the qualification. The way to prevent the wrong results that sometimes occur as a consequence of following the wrong characterization made in the petition by the judge is to ensure that all lawyers make the right qualification at every stage of the case. What should be understood from this stage is the necessity of paying the maximum attention to the determination of the right legal relationship by the lawyers, of course. Sixth subtitle is legal relationship. The methodology for how the legal relationship should be determined is explained in detail in this chapter. Since it is understood that the legal relationship is the basis of the claim and the defense, it is of great importance to determine it correctly. Hirsch clearly stated that the legal relationship cannot be sought arbitrarily and explained the method of how to make the correct qualification for each legal field. He has included these explanations in detail in his book, specifically for each field of law. According to these explanations, although it is not possible to understand the legal relationship directly and easily from the case, it is great importance to detect it using the right method. The seventh subtitle is schema. The determination of the legal relationship should not lead directly to the conclusion. On the contrary, the research should continue and different possibilities should be emphasized. In this way, the belief that the claim is justified is strengthened because there are different connections. In addition, the probability of being wrong in characterization decreases with the existence of different theses. Hirsch emphasizes the necessity of identifying different possibilities and evaluating them by showing them with a diagram and putting them into concrete form. He explained some of the schemas that we are all accustomed to seeing in law school actually as examples in his book, and he emphasized the necessity of these schemas. For example, a very basic example is he explained with drawings that the legal relationship between two people is indicated with a line, and if this relationship puts only one of the parties in debt, a unilateral arrow should be used. And if it puts both parties in debt, a double-sided arrow should be used. Hirsch thinks that judgment should not be made without drawing a diagram and examining the case in a concrete way by associating it with legal relationship. The eighth subtitle is legal elements of legal relationship. At this stage reached so far, it is possible to talk about only one possibility and estimation. What needs to be done to understand whether this possibility is is true is to examine the law, doctrine, and court decisions, and make the evaluation based on all of this information. Examining the law alone is not enough. What should be understood from a single term in the law is determined only by doctrine and court decisions. The formula needed to solve the legal problem is in the books. Logic and analysis are based on information. It is not possible to reach a solution without a book. At this point, the important thing is not to know many, but to know how to reach the right information. Hirsch emphasized that the lawyer should not rely on his own knowledge and intelligence, but rather recheck and control and read every piece of information again and again. It should be understood that the qualification evaluated in the 8th stage should be weighed using the law, scientific writings, and case law, and the conclusion should be reached after all of these readings. The 9th subtitle is application of the law to the case. At this stage, the application of the abstract rules to the concrete case and the evaluation of the case with the rule of law should be made. We have said that the first part of the law article contains the necessary conditions for the application of the rule to the case. In a concrete case, this evaluation should be made and it should be decided whether the rule will be applied to the case. For the lawyer, he evaluated the situation in terms of the importance of getting accurate information from his clients about the concrete case. It will be possible for the lawyer to make the most accurate assessments if he knows the real and complete case. In short, it is not correct to apply the law without obtaining the right information. 10th subtitle is unraveling of legal relations. When there's no ambiguous points in the case and the conditions in the case are determined, and if it is theoretical, it can now be decided whether it complies with the legal relationship. In the first case, it can be decided that the estimated legal relationship does not partially comply with the definition in the rule. In this case, it would not be correct to include it in the petition and to make a request based on this relationship. Likewise, in the second possibility, even if the legal relationship does not comply with the definition in the law, a request should not be made in this direction. Finally, if it is concluded that the legal relationship fits the case, this situation should be checked and proven again and again. According to Hirsch, it is never sufficient for a legal relationship to be compatible with the case, because there is always a possibility that the court will find the evidence insufficient or that the other party will refute this thesis. For this reason, the determination of a single relationship is insufficient and researches should always be continued to prove other relationships. So to speak, B, C, D plans should be obtained. The examples Hirsch gives from case law in his book also reveal how useful it is to associate an event with different legal reasons. The step that Hirsch emphasizes in this section is on the benefit of diversifying the legal relationship on which the right of claim is based. 11th subtitle is classification. The lawyer must solve the legal problem, make an accurate diagnosis, and reach a solution. The method for this is to find the right law, the fulcrum in Hirsch's words. The priority here is to explain the concrete case with a correct methodology. For this, the case must be described in order in which it occurred. In addition, it should be evaluated with the eye of a lawyer and unnecessary details should be removed. While doing this, important details in the case should not be overlooked. In the second step, the subject matter of the lawsuit must be convincing. However, convincing means that the lawsuit is rightful before the law, and if the claims are not convincing, it should be rejected. When it is decided that the lawsuit has legal basis, the third thing to do is to examine the views of both parties in terms of justification. The next step is the case, which is examined in terms of justification, is to examine the dispute in terms of demurral and affirmative defenses. The next stage is about responses to defenses from the other side. It is important to distinguish between demurrals and affirmative defenses, which are so important that they prevent the opening of a lawsuit. After the demurrals are resolved and the legal relationship on which the lawsuit is based and the law are decided, the defenses should be examined. It should not be forgotten that there may be more than one case behind the lawsuit. The 12th subtitle is external form of problem solving. While solving the problem, it is of great importance that the issues identified one by one are correctly classified and presented. This issue is also explained in detail in the codes of civil procedure. What should be included in the petition is generally determined with strict limits, so much so that correct preparation of the petition might result in the rejection of the case. In this subtitle, Hirsch pointed out the external appearance that is the form of the petition both in terms of aesthetics and content. The necessity of the petition to be concise and clear emphasized that it must meet the conditions specified in the procedural law. 13th subtitle is the study plan. The method to be followed for the correct appearance, clear and concise expression mentioned in the previous step is explained in this title. It was stated that all the arguments should be in a logical order and the desired form could be reached with an appropriate style without going out of the subject and without repetition. Hirsch emphasized that the right result cannot be reached without a work plan. 14th subtitle is scientific evidence and interpretation. Every argument must be followed by proof. In this section, Hirsch talked about the reasons behind laws and decisions and the issue of interpretation, which is the biggest duty of a lawyer. The main idea here has been the importance given to the logical sequence of the desired ideas. The 15th subtitle is oratory and responsiveness. Although the ability to speak is important for every person, it is more important for a lawyer. On the contrary, a hollow oratory has negative effect on the judge. No judge has the time or patience for a lawyer who strays from the main subject and talks at length. Here, an empty oratory skill will also show itself in the questions asked. A good lawyer should be able to give credible and rational answers to a question for which he was not prepared. Here's advice in this section is to speak concisely and rationally at the hearing and to be quick-witted to the questions asked. The 16th subtitle is the trial. In this section, it was emphasized that the hearings should be well prepared and that important points should be explained clearly and concisely as stated in the previous stage. And the last 17th subtitle is clarity and objectivity in wording. First of all, the arguments should be arranged rationally and the ideas should be explained as briefly and clearly as possible. The explanation should be made depending on the subject without going into unnecessary details. As a professional rule of law, the lawyer should explain his ideas within the framework of the law. The lawyer's wording should remain respectful and should not engage in hostile attitudes. The lawyer needs to be cautious and able to remain impartial when defending. In addition, the lawyer should have a good command of the language, especially taking care to use the terms belonging to each field with their true and correct meanings. It is important that the wording is clear and understandable to everyone. The fact that the language used is far from intelligible does not bring any benefit, and it is not possible to speak of a lawyer who cannot be understood as making a good defense. In short, it is recommended that the allegations will be explained clearly and concisely in a language that everyone can understand. Hirsch's recommendations under 17 subtitles in this method book in practical law can be summarized in this way. Again, it should not be forgotten that what is explained in this video is a summary of the information in Hirsch's book after filtered by me. I strongly recommend reading the book in order to absorb the methods of practical law, and I also strongly recommend the book to be translated to English. Thank you so much for listening.